suppose the reasonable time limit applies, and I know maybe we don't have to decide what that means here, but if we were to decide that, would you agree that there should be a lot more flexibility with regard to the reasonableness of a filing when what is being contested is a judgment that's void ab initio?
No.
You don't think that could?
I think a default judgment might. Like, I think a default judgment just raises implications. You need to hear of it, but just I think at least the way the rule's set up, maybe how void it is somehow bears on why you took so long. But generally, why you took so long, it goes to why'd you take so long? I mean, when did you know of it? Did you ever, was it a burden because, you didn't want to go all the way and file this motion? And also, is prejudice arising? But sure, reasonableness is an abuse of discretion. And so, of course, a court can basically do whatever it wants, assuming,
And do you think there's any category of cases in which a reasonable amount of time can, in fact, be any time?
No. I mean, that's infinity. So,
that there's some category of cases that because of some feature that they have,
no.
that whenever you raise it, it will be considered.
No, by definition, it's conceiving that there could be an unreasonable time and any time. Now, that being said, you could say, I'm happy to give you any number, 1 billion years. I'm just not going to concede any because it has to be reasonable. And in the bankruptcy context, there's almost always going to be prejudice because the trustee is trying to close the estate. And I'm talking about notice. This is a person who has notice and there's prejudice creeping in. But if there's no prejudice, then, I wasn't going to say any time, but a lot of time. Most people who get a default judgment, once they know about it, certainly if they're sophisticated, they try to get rid of it. If they're unsophisticated, then sure, you're not going to make the person hire a lawyer. You just wait, whatever's reasonable.